You're tuned in to Agriculture Today, and we start our Wednesday show with some information from K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Talking about probate fees today, and first, what are probate fees?
Well, a probate itself, and the probate fee is what you pay to go through probate of your estate. But what probate is the process under which a decedent's will is verified as a valid and legal will, and then it's the process of distributing the assets of the decedent's estate. So probate is a process where the will is declared valid and then the assets distributed.
And why is this something that often people care about?
Well, we've got a couple of choices at death in terms of how we want things handled, and one is that we could go through a formalized probate if we have a will, and we could have an intestate estate, which it's not really the same thing, but it kind of is, where the state's will, so to speak, the intestacy statute is utilized and the assets are distributed in accordance with that. As an alternative approach, we could have a trust created during life that becomes irrevocable at death, or we could transfer assets away during life into an irrevocable trust. And it wouldn't be a probate at death, but there'd be something comparable. There'd be a trust administration at death. And we worry about those things because they mean different things. They have different implications. The fee structure is different in a probate than it is with a trust administration. Trust administration is private. A will, once it becomes probated, becomes filed as a public record, and people can look at that, and they can see where your assets went, what assets you owned, and who got them. With a trust administration, all that the public gets to see is a certificate of trust existence. They cannot see the terms of the trust. And so privacy is very important to a lot of people, particularly farm and ranchers. And so you want to think, if you haven't thought about this process already, give some serious thought as to how you want things handled upon death.
And thinking about how things are handled, specifically today we are talking about Kansas, and how are Kansas probate fees handled?
Well, in Kansas, state law specifies that every fiduciary, the person that is typically known as the executor in this context, is allowed their necessary expenses incurred in the execution of their trust and shall have, as the statute says, compensation for services, and those of his or her attorneys shall be just and reasonable. So that's the statutory language. That's kind of flowery language, but the last part of that's the key. The fee for handling an estate that an attorney charges is to be just and reasonable. It has to be a reasonable fee. There is no statute in Kansas that allows for a percentage fee for handling a decedent's estate. It's not specifically disallowed if the percentage amount is backed up with itemized timesheets and is ultimately deemed reasonable by the probate court. So in essence, in Kansas, probate fees are based on an hourly rate for the amount of hours reasonably spent working on the estate. In addition, the attorney's fee for handling a decedent's estate is also based on the 8 factors of the Kansas Rules of Professional Conduct. And the probate court, the court that is administering the decedent's will, considers those 8 factors when determining whether the fee charged by the attorney is appropriate.
And something that you mentioned, Roger, is that it has to be an hourly rate and not a flat rate. And is that something specific to Kansas?
That's right. It is specific to Kansas. In Missouri, it's different. Missouri allows for the charging of a flat percentage rate based on the gross estate value of the estate. That's what I'm talking about when I say percentage. Kansas does not. Kansas doesn't disallow it. It just says if you're going to charge a flat percentage of the gross amount of the value of the decedent's estate, you better have time records that back that up. Because you just can't say, here, I've done all this, I'm done with the estate now, I've worked on it the last year, it's all done, here's my bill for 3% of the total, or 4%, or whatever. And the court says, no, you can't do that. Where are your records? Well, I didn't keep records. No, the court will require you to put something together so the court can estimate a fee. But you cannot just have a flat rate in Kansas unless it's supported by itemized billing.
And Roger, could you tell us a little bit about a case we've recently had in Kansas that shows this law in action?
That's right. We had a county district court, so the probate court in Chautauqua County, that applied the 8 factors of the Kansas Rules of Professional Conduct to a situation where the attorney did not provide billing records. He didn't keep itemized timesheets. In fact, he told the executor that he was not going to do that. The executor requested it. And he said, no, not going to do it. And he said, we've done a lot of, quote, off-the-books work end quote, for this individual, this decedent, before she died, and they were going to catch it up in the estate. Now, that's a bad thing to say. You don't want to say that. And he also said, well, this is the way it's always been done. We're going to continue to do it this way, which is also something unfortunate that I think is a problem in the bar across the state. And that is that we just continue to do things the way that we've always done things, and we don't pay attention to what the existing rules are at the time. And the rules in Kansas changed with a court case back in 2009, and the attorney in this situation didn't pick up on that. And so the court looks at the 8 factors, and real quickly, how much time and labor did you put into it? How difficult was the estate? And that's going to be based on the type of assets that are in the estate. What's the level of skill that is required by the attorney to handle the estate, which is tied to the type of assets you're dealing with? Do you have difficult tax questions that are involved, for instance? What's the likelihood, if it's apparent to the client, that the acceptance of the employment by the attorney will preclude other employment that he or she could be doing? Again, that ties into that first one, is how difficult is this job? How difficult is this estate? The next one is the fee customarily charged in the locality for similar legal services, and that can, in some situations, come in as a factor. Next one is the amount involved and the results obtained and the time limitations imposed by the client or by the circumstances. Another factor is the nature and the length of the professional relationship that the attorney had with the client that has now died. And the next one is the experience, reputation, and ability of the lawyer or lawyers performing the services. And then finally, whether the fee is fixed or contingent. Those are factors that the court's going to look at.
And in this case, this is something that the conservator caught and really saved the family quite a bit of money.
Well, you raised a point there. The executor of this estate had previously been a conservator for the decedent for about 7 years before she died. And he was handling her matters, her affairs, and the attorney was representing the conservatee, the lady here in this instance that eventually passes. And the attorney would bill for his services in handling financial matters and so forth that the conservator had to deal with. And there were legal issues that would come up periodically in that 7-year period. But the attorney would always file an itemized statement with the conservator, and the conservator would look it over, and the court would approve that, and there was no problem. Well, upon death in 2021, after having served as a conservator for 7 years, the conservator was appointed the executor of the estate, and wasn't receiving itemized billing statements. And he communicated with the attorney, I want that. My expectation is you're going to continue to provide itemized statements. And the attorney at that point answered him in an email and said, no, they don't have any plan on doing that. He said, quote, I feel comfortable asking for a fee based on 3%. If you want to oppose it, that's fine, end quote. And it goes on and on. And he said, no, you're not going to get an itemized billing statement. We're just going to take 3% of the gross estate value, which was a little bit over $4.5 million. So he does all the estate work, and at the end of it, he turns in his fee, flat 3%, so $137,000 fee. And the executor challenged that, and the county district court applied the factors and said, look, you cannot, without billing records, you cannot charge a flat fee. You have to have your billing records that support your fee amount. And he didn't have that, and the court cut $80,000 off of the fee amount and trimmed that way down. So it's a really rough case, but I think it sends a message to attorneys handling estates in the state of Kansas. The district court here is right that you've got to be careful. You have to follow those Kansas rules of professional conduct.
So for people who maybe are dealing with the probate and aren't the attorney or aren't the court, what do you really want to remind them about?
Well, it's a couple of things. One is you can avoid this whole problem if you would have a trust. A trust will avoid probate. Now, it doesn't avoid cost. There's still a trust administration process at the end, but that's usually less expensive than what would be a comparable probate process, even though the cost up front to create the trust would be a little bit more. So if you don't want to deal with the probate process, plus the public aspect of a will becoming published, a public record when you die, then you want to go the trust approach. And so that's one aspect of this. The second one is the message to the members of the bar that handle estates, and that is that you cannot just simply charge a flat rate. You have to be familiar with those Kansas rules of professional conduct, keep good time records, and stay in good communication with the executor and meet those expectations of the client.
Roger, I appreciate you taking the time to join us today and share with us some information when it comes to probate and probate fees.
Thank you, Shelby.
That was Kansas State University and Washburn law professor Roger McEowen. If you'd like to read more about this topic, you can do so from one of his recent blog articles. The article is titled Probate Fees, How Much Are They? There are a few different ways you can find it. I will link it in today's show notes on agtoday.net. You can find it on his website at washburnlaw.edu/WALTR, or you can also find it on agmanager.info or on RFD TV. I will put links to all of these in today's show notes.